Hello and welcome to the course on litigation before UN treaty bodies by the International Commission of Jurists. This course is aimed at lawyers and human rights defenders in the Middle East and North Africa region. My name is Jurgen Schurr and we'll spend some time together and go through a number of videos in which I'll provide you with an overview of the UN treaty body system, present the concept of strategic litigation before going through the different stages involved in litigating a case before the UN treaty bodies. We'll also look at the burden of proof in such cases and the type of information and the facts that you will have to present to the UN treaty body in support of your case. Before we start, a brief word about myself. In my day job, I work as the head of law for Lawyers and Justice in Libya, where we also litigate before treaty bodies on behalf of victims of gross human rights violations such as torture, arbitrary detention, extrajudicial killings, and enforced disappearances. I previously worked for an NGO called Redress, which also litigated extensively before treaty bodies in the UN and also the African, Inter-American, and European human rights systems. The regional and international human rights systems provide us with an excellent opportunity to hold to account the state in cases where it failed to provide a remedy to victims of actions that the state was directly or indirectly responsible for. As such, these cases can also provide some measure of justice to victims and, as we will see in the next video, provide incentives for broader reform aimed at preventing similar human rights violations in the future. So what are the UN treaty bodies and why are they important for victims of human rights violations? You remember that there are 9 core international human rights treaties developed under the guidance of the United Nations and ratified by states to varying degrees. These treaties cover specific issues ranging from racial discrimination, torture, enforced disappearances, the rights of persons with disabilities, the rights of women, the rights of children, and the rights of migrant workers. There are also 2 general treaties covering civil and political rights, the International Covenant on Civil and Political Rights, or ICCPR, and the International Covenant on Economic, Social and Cultural Rights, or ICESCR. Each of the 9 treaties has a monitoring body, or a committee of experts, which is responsible for monitoring the implementation of and compliance with the relevant treaty provisions by its states parties. I'll refer to these throughout this training as either treaty or monitoring bodies or committees. There exists also a subcommittee for the prevention of torture, which is monitoring compliance with the provisions of the optional protocol to the Convention Against Torture. So in total, there are 10 different bodies or committees. You can find an overview of the different treaties and corresponding monitoring bodies on the website of the Office of the High Commissioner for Human Rights, which is also available in Arabic. And I'll provide the link to the page in the notes for this video. Each of the treaty bodies has a set of rules of procedure, which sets out its composition and working methods in more detail. These rules can be important for anyone engaging the treaty bodies to make sure that any engagement, for example, the submission of a complaint, complies with the relevant rules of the committee. Each monitoring body or committee is composed of 10 to 25 independent experts, depending on the treaty body. These experts or members are elected by states parties and usually serve for 4 years and up to 8 years if they are re-elected. Ideally, members should be experts in human rights and represent various regions of the world, as well as ensuring a balanced gender representation. The members are not paid for their work, but reimbursed for expenses. And each treaty body is supported by a secretariat and a petitions unit within the Office of the High Commissioner for Human Rights. They meet at least twice a year in Geneva or in New York to review state party reports, to adopt general comments, and consider individual communications. Let's look at that in more detail now. So what do the treaty bodies do? The treaty bodies are important because they support states parties to implement their obligations under the relevant treaty in practice, and they remind them of those obligations. Ratifying a treaty is not enough, as we all know. It must be implemented in practice. Treaty bodies can help with this in various ways. The treaties, for example, oblige state parties to report periodically to the relevant treaty body about the implementation of the treaty in their domestic system. The treaty body will examine the periodic report submitted by the state party, setting out, for example, specific laws adopted to give effect to the treaty or specific institutional arrangements, such as, for example, access to safe shelters to protect women victims from violence, in line with the Convention on the Elimination of Discrimination of Women. State periodic reports provide opportunities for non-governmental organizations to submit so-called shadow reports, setting out how the state does or does not comply with the relevant treaty obligations. The treaty body will examine the reports submitted and then adopt so-called concluding observations, which is usually a list of recommendations to the state about measures to be taken to better comply with treaty obligations. These recommendations can then be used for domestic advocacy, and we can also use them in litigation, as we will see shortly. Most treaty bodies adopt general comments on specific aspects of the relevant treaty. These help clarify the meaning of certain obligations. So, for example, the Committee Against Torture in 2012 adopted a general comment on victims' right to redress, setting out in detail what states need to do to ensure they comply with their obligation to provide victims of torture and ill-treatment with full and adequate redress as provided for under Article 14 of the Convention Against Torture. The Human Rights Committee has adopted a range of general comments on the rights in the ICCPR. These are important sources for states to consider when implementing a treaty in practice. They are also important for us when we file complaints, as they are an authoritative and persuasive interpretation of states' obligations, even if they are not, strictly speaking, legally binding. They also give us a good idea of the relevant treaty body's position or interpretation of relevant standards. Treaty bodies are also important, however, for victims of violations of the relevant treaty, and this is what we are examining for the purposes of this course. So where a state violated an obligation of a treaty, for example, where its law enforcement and judiciary failed to investigate police officers using excessive force, or where state's legislation is in breach of an obligation, the treaty body might be in a position to examine the alleged violations and issue a decision. Out of the existing 10 treaty bodies, 8 have the competence to consider complaints from victims of violations. These complaints are also called individual communications. There is currently no such possibility for the Committee on Migrant Workers, and the Subcommittee for the Prevention of Torture does also not consider individual communications. We'll examine this aspect in more detail in the next sessions. The communications or complaint procedure before the committees is crucial for victims because it provides them with an opportunity to obtain justice at the international level where the domestic courts have failed to provide a remedy. Whether or not you can file a complaint on behalf of a victim depends on whether the state in question has ratified the treaty and has recognized the competence of the treaty body to receive and examine individual complaints. So we need to check ratification of the treaty and that the state has, depending on the treaty, either ratified the optional protocol, giving the treaty body the competence to examine complaints, or issued a declaration specifically to that effect. To sum up, what opportunities for civil society and lawyers working with victims of violations exist? We have 10 treaty bodies monitoring state compliance with relevant treaties. These treaty bodies are important partners for lawyers and non-governmental organizations supporting victims of human rights violations. They can consider periodic reports, adopt general comments, and under certain circumstances issue decisions on individual complaints. Where the treaty body finds that a violation occurred, they will issue a series of remedy recommendations for the state to comply with, so that the victim's harm is repaired and the repetition of the violation is prevented. There's more to say about what treaty bodies do. You can find that information, including in Arabic, on the website of the High Commissioner for Human Rights. Links to that information are provided in the notes for this video. Next to the treaty bodies, there exist other opportunities with the UN human rights system to submit a complaint about human rights violations. We can, for example, use the UN special procedures of the Human Rights Council, who are independent human rights experts. These exist in relation to specific themes, such as the Special Rapporteur on Torture, the Special Rapporteur on Violence Against Women, as well as in relation to specific countries, such as, for instance, the Special Rapporteur on Palestine or the Special Rapporteur on Syria. Specific working groups also exist as part of the special procedures, including the UN Working Group on Arbitrary Detention and the Working Group on Enforced or Involuntary Disappearances. These are not treaty bodies, yet the special procedures are an important complement to UN treaty bodies, as you can submit complaints to them irrespective of any treaty ratification. So if, for example, you can submit a complaint for torture or enforced disappearances against Libya, even though Libya has not ratified the UN Convention Against Torture nor the Convention on Enforced Disappearances. Special rapporteurs are appointed by the Human Rights Council and usually hold a mandate for 3 years, which is renewable once. When they receive a complaint about specific human rights violations, they send communications, such as urgent appeals or allegation letters, to the state concerned and ask them for clarification. They can be useful to raise attention to a specific case, and they can act quickly when, for example, a victim has been arbitrarily arrested and is forcibly disappeared. The competent special rapporteurs, for example, the Special Rapporteur on Torture, together with the Special Rapporteur on Human Rights Defenders, may then issue an urgent appeal to the government concerned to provide verifiable information about the whereabouts and well-being of the victim. We will not examine this process in detail, as it does not, strictly speaking, amount to litigation. Special rapporteurs do not issue decisions or findings on a specific case. They seek to communicate concerns to the government. They can support litigation before treaty bodies, for example, to show that a specific violation has been brought to the attention of a state, and that despite such notice, the state has failed to respond to the violation. Special rapporteurs may also support a complaint with an expert testimony or through a third-party intervention, but submitting complaints to special procedures is a different process and the objectives are different. An exception is perhaps the UN Working Group on Arbitrary Detention, which is also a special procedure, but it issues findings on specific cases and may also recommend the state to provide specific remedies. So, for example, at Lawyers for Justice in Libya, we have submitted complaints regarding arbitrary detention to the UN Working Group rather than the UN Human Rights Committee. Which processes to use depends on the individual case and is something we'll come back to in the following videos. More information on UN special procedures is available on the website of the Office of the High Commissioner for Human Rights, with relevant links provided in the notes for this video.